Supreme Court this week was brought by 26 states who are challenging the health care law on several points. Texas is one of those states, and joining us now to talk about why he believes the health care law doesn't pass constitutional muster, Texas Attorney General Gregg Abbott. Great to have you in studio today. Thank you so much for coming in.
Great to be with you.
All right, you're one of the states that is challenging this. So, of course, at the core is the mandate, and that is the big debate. We had a Harvard professor, former Solicitor General Charles Fried at the top saying, everybody's involved in health care at some point in their lives. So it is a stream of commerce, and Congress had every right to regulate it. You say not so.
Not so. First, I want to applaud our 25 other states who joined with us in this lawsuit. But second, the reason why we won in the district court, the reason why we won in the Court of Appeals is because this mandate is different, is unprecedented, and will change the way that government operates. If Congress can force someone to go out and purchase health care insurance, they can force someone to go out and purchase anything. Shannon, going back into that argument, there are certain things that all of us interact with more than health care. Access to food, water, clothing, shelter. Can Congress make us purchase food, water, clothing, and shelter? The answer is no, because Congress does not have that power, which is why the United States Supreme Court has set aside 3 days to hear oral arguments in this case, because if this law is upheld, it will change the way that government operates in the United States of America.
Well, at least some conservative judges in the lower courts have been convinced that this mandate is constitutional. These are Republican appointees who upheld the mandate at various levels in the lower courts. How do you think the conservative justices on the Supreme Court square that? The fact that people who are probably very like-minded with them in judicial philosophy and temperament have upheld this mandate?
I think the court will be able to look at 3 primary things that will allow them to strike down Obamacare. One is that the law is unprecedented. They will not have to overturn any case law in order to strike down Obamacare. 2, the law is unlimited, like what we just talked about. If this law is upheld, the court will realize they will establish a new precedent that gives Congress unlimited power. 3, most importantly, Shannon, the law is completely unnecessary. Congress legally could have addressed health care and health insurance through a legal method that they were empowered to do so under the tax and spend clause. They purposefully did not go down that pathway and chose an illegal, unconstitutional pathway to impose this mandate on all Americans.
What do you make of the arguments of those who point to a couple of the so-called conservative justices, Justice Scalia and the swing vote, oftentimes Justice Kennedy, even the Chief Justice, John Roberts, and point to old opinions they either authored or signed on to that did recognize a wide sweep of federal powers under certain circumstances?
2 things about those justices. One is twice in the last 15 or 16 years, they have ruled to strike down laws imposed by Congress as violating the Commerce Clause, which is the provision of the Constitution that Congress relied upon here. But secondly, if you look at Justice Scalia in particular, he has been the architect behind the legal doctrine focusing on activity. He insists that for the Commerce Clause to apply, there must be an activity. The whole premise of our argument here is inactivity, the failure or refusal to participate in an activity. So we think that our argument that people who choose to be inactive and not purchase health care insurance fits well within the architecture of the legal opinions created by Justice Scalia.
What about the issue of severability? This issue of if they take out the mandate, can the rest of the law, and there's so much more, can it survive? The House version of this bill originally did have a severability clause. It did not make it into the final legislation. Do you think that will speak one way or the other to the justices about whether the rest of this law can stand up on its own?
Well, it's interesting because the states argue that it is not severable. The United States Department of Justice argues that it's not severable. We think the court will agree because the individual mandate is such a leading component of the entire health care law. As the Department of Justice itself has argued, without the individual mandate, there is no funding mechanism to uphold the remainder of the law. So once the court strikes down the individual mandate, the rest of it should fall regardless of whether or not it is severable.
All right. Well, it'll be an interesting week. We will see you over there at the court, and we'll watch and see how this turns out for the 26 states, including Texas.
Thank you, Shannon.